You want to support Roland Martin Unfiltered? Be sure to join our Bring the Funk fan club. Every dollar that you give to us supports our daily digital show. There's only one daily digital show out here that keeps it black and keep it real as Roland Martin Unfiltered. Support the Roland Martin Unfiltered daily digital show by going to RolandMartinUnfiltered.com. You can make this possible. Today, Elizabeth City, North Carolina, District Attorney Andrew Womble announced that he is not going to pursue charges against the sheriff's deputies who shot and killed Andrew Brown Jr. on April 21st, saying the shooting was justified. He said the officers reasonably believed deadly force should have been used in the shooting of Brown.
On Wednesday, April 21st, 2021, Andrew Brown Jr. of Elizabeth City, North Carolina, was shot and killed by 3 deputies with the Pasquotank County Sheriff's Office. This incident occurred at the residence of Mr. Brown, located at 421 Perry Street in Elizabeth City, North Carolina. After reviewing the investigation conducted by the North Carolina State Bureau of Investigation, Mr. Brown's death, while tragic, was justified because Mr. Brown's actions caused 3 deputies with the Pasquotank County Sheriff's Office to reasonably believe it was necessary to use deadly force to protect themselves and others.
Only 44 seconds had passed between the time officers jumped out of their vehicle and Brown was shot to death. This right here is the video footage that he showed at today's news conference. You see the video where all of a sudden, there's audio, please turn it up. You see them jumping out of the car. Again, DA Andrew Womble claimed that because Brown moved the vehicle, that put the lives of the sheriff's deputies in, well, he claims it put them as a threat. Joining us right now is Harry Daniels, one of the attorneys for the Andrew Brown Jr. family. So they fought the release of this for all of this time. You heard the DA claim that the officers' lives were put in jeopardy. He initially said in the first court hearing that the car was moving towards the officers. In that video there, you see Brown back up. You don't see him hitting one of the officers. What do you make of what Andrew Womble said today?
Roland, Andrew Womble, in my opinion, and this is my opinion, is that he has no integrity. He should not be presiding and making any decision as relates to this case should be prosecuted or not. He is intertwined with those officers. He worked with those officers on a daily basis. He is basically put in a position to make a determination as whether his own people violate the law. So in simple put, he is presented with the job of having to prosecute his own prosecuting officers in Pasquotank County. The reason why I say he has no integrity, he mentioned that the reason why he did not call the family and give them heads up in his decision, because a conference or meeting he had with the attorneys before, it was contentious. That's absolutely not the case. That's 100% a lie. In fact, I have communication after that meeting with Mr. Womble and extensive long telephone conversations with Mr. Womble. He chose not to call call the Brown family, because he knew that he was going to have to tell them something that's inconsistent on the video.
So he had this news conference. So just to be clear, he had this news conference today, gave the family no heads up, just out of the blue, he's announcing no charges.
That's correct. That's correct. His position was that it was a heated, contentious relationship between the attorneys. When we first met, I was the attorney that met with him. Ms. Laster was the attorney who met with him. We shook hands and we said we're going to try to work together to get to the bottom of it. He, in fact, called my telephone. We had a long conversation after the fact. So his position there is an absolute lie. I'm not even going to say it's a mistaken or belief. It's a lie. I have the telephone communication, text message to prove that he's lying, and I'm standing by it. So that tells me the type of character we're dealing with. So were we shocked that he didn't bring charges? No. He basically set it up in court. What he said before, he wasn't, that the vehicle went forward then, and not until only then shots were fired. The video, objective evidence, is crystal clear in this case. I mean, it's so disheartening that a man can be killed in the manner he did, and the DA just took an oath to do his duty, completely dereliction thereof. And there's nothing that he can say, any law that he can try to quote, or any totality of circumstances, legalese that he can quote to make the American population to believe any otherwise. This was an unjustified killing of Andrew Brown. Unjustified killing.
So what now? So is the only, first of all, he's the DA. He gets to decide whether it goes to the grand jury, if there are any charges, any indictments. So the only hope now is the federal investigation. Or tell us, go ahead.
Sorry, go ahead, Roland.
What now? Do we hope that the feds launch an investigation and take it to a grand jury?
Well, the Department of Justice is currently investigating this matter. I'm sure that investigation is deeper or more broad than the surface in which the SBI or investigated matter. So we hope that Department of Justice, in particular Main Justice, will be moving forward to bring charges, civil rights charges. This is a clear case where civil rights charges should be brought. We can break this video down in many ways of Sunday. We can say, you can say, well, he appears to be moving towards the officers, putting at least one officer to say, well, he was putting, threatening with the vehicle. Well, that officer gets out the way, okay? And Mr. Brown drives by. Roland, where's the justification now? To unload as a firing squad in this man's vehicle, ultimately striking and killing him. But it's our contention that he was never a threat to the officers. As you could see, he backed up. If it was a threat to him, he could have went towards them. He backed up, turned his wheel to the left, and it was two officers on his left and the right, and he drove between them. One officer touched the vehicle, very fast, touches the vehicle, and pushes back, as while the vehicle moving at a very slow pace. No threat whatsoever. Roland, that officer did not shoot his gun. The officer that the DA is talking about was threatened. He didn't shoot his gun at all. 4 other officers who were on scene did not shoot their guns. So when you're talking about an objective, reasonable officer, well, hell, you got 4 objective, reasonable officers who's out on the scene who chose not to shoot and kill the man. But you have 3 that did. 3 that did. So you have a policy in Pasquotank County. They have their own policy, use of force policy. It's policy 30000 for Pasquotank County Sheriff Office. that you do not shoot into a moving vehicle. You avoid shooting into a moving vehicle by all costs unless you are threatened and you have no choice but to shoot into that moving vehicle. One of the reasons is because you don't know who's in the vehicle. It could be children in the vehicle as such, or you could shoot an individual and that person lose control and possibly cause injury or death to an innocent bystander or somebody else. So that's their policy. Their policy specifically says that you try to move out the way. So let's take their policy. The deputy, for argumental purposes, he was in the way, he moved out the way. He followed the policy. You get out the way. You don't shoot in the vehicle, you get out the way. But after he moves out the way, the barrage of fire shots begin. So, violation of own policy. Further violation of own policy is you shoot a suspected felon. It's specifically forbidden in Pasquotank County to do so. Forbidden to do so. But when you look at this policy versus what we saw on this video, no threat. If it was a threat, the threat was eliminated, but they still killed it. They still killed it.
Also,
no justification.
It's interesting here that, so he shows this video forcing cameras to point their cameras at the screen. He won't release the video.
Well, the court has to release the video. He, in essence, by showing the video, he released a portion of the video because obviously media recorded the screen, obviously. However, at this point, there's no question about the release of the video because he says he's not going to press charges. So there's no real reason for the video not to release. In fact, the public have seen a significant portion of the video that we believe are the relevant parts, but I think there's other relevant parts to this video. For example, I believe one of the main reasons why they don't want the entire video released because you may have incriminating statements on the video by one officer. Hey, man, why did you shoot? Well, I didn't shoot. Or I thought that he had a gun. Or I thought this. Incriminating statements. This district attorney, Roland, sounded like a damn defense attorney. He was poised in position at all costs to defend the acts of these officers. He was not an ambassador of justice. He was an obstructor of justice. That's what he did. And when the reporters started questioning him, challenging him, based on what they saw and based on what he concluded, he didn't want to answer any questions anymore. He wanted to deflect. He wanted to talk about something else. That is the exact reason why it should have been an independent prosecutor appointed on this case for transparency and a neutral decision maker. Let's be very mindful. The SBI did not conclude that the shooting was unjustified. They make no conclusions. The DA made the conclusions, not the SBI.
What was the family's reaction to one being surprised by this news conference and hearing what he had to say?
Well, they really was shocked and surprised that he was not going to bring charges. They kind of knew that based on his unwillingness to speak with them early on, unwillingness to communicate with the attorneys to work in tandem early on, his unwillingness and his statements that he made in court, be mindful that his Mr. Brown's 92-year-old grandmother, a lot of his aunts and uncles was in court when the DA made the position that we believe that the shooting took place once Mr. Brown moved forward. So he already prefaced it as though he was going to call the shooting justified. So there was no shock. But what is downright disgraceful is that this man did not have the decency to call this family and let the family see the video and tell the family what's his decision. 2016, the district attorneys of North Carolina came up with a standard practice committee. And inside their standard practice committee, that was one of the things that they determined you should do. That even if you're not going to bring charges, let the family know, get the family an opportunity to come in and explain to them. Any other use of force cases, I've been a part of the lawyer and the DA decided not to bring charges, they would at least afford the family with the opportunity. He didn't. He has his own motives, agendas. I don't know. He is running for Superior Court judge. Maybe he don't want to piss off his potential voters or constituents in that particular county, that particular circuit that he's in. But one thing I will tell you, that what he gave today and his reasoning was subjectively his reasoning, because the law that he applied, the law he's used, was not correct. He stated that when Mr. Brown, if he refused to obey to the officer's command and stay in the vehicle, he believed that he's using the vehicle as a weapon. Well, what if Mr. Brown just decides to stay in the car? Is he using the vehicle as a weapon? No. This district attorney believes that. So that shows his incompetency, and he's incapable to preside, to make any decisions, and his lack of integrity that I personally know he has.
This is certainly sad. It was expected by his actions.
Right.
And I got to ask you this here. I got to get your thoughts just on this, the comment that he made during this whole deal, where he literally talked about how he didn't have to deal with attorneys because they weren't under the bar in North Carolina. I mean, how arrogant is that?
Well, that's and some folk don't realize that it's some constitutional rights and some things in it a long time ago. But nevertheless, what I will tell you is that Rule 5.5 of the North Carolina Rules Professional Responsibility Unauthorized Practice of Law is very clear that if an attorney, myself, Ben Crump, Bakari Sellers, associate with an attorney in North Carolina, Chantel Lasser, Chance Litch, and you're not engaging in anything that requires you to come to court and argue before a court, you do not have to file pro hoc vice. That is a discussion I had with the county attorney. That is what he did not want to hear. The judge doubled down on it. The county attorney doubled down on it. And the district attorney doubled down on it. What you got is a conspiracy between the judge, the district attorney, and the county attorney, because both of them make the same statement, and it do not make sense. It don't make sense. It is not the law, the rule of law in North Carolina bar. So when I use the word conspiracy, I don't know if they talked about it. So I'm not going to make allegations as such, but it's ironic that all three of them said the same exact thing that is not in conformity with North Carolina rules of professional responsibility in the North Carolina bar. That's Rule 5.5 on the authorized practice of law in North Carolina. You can see it, read it for yourself.
Attorney Harry Daniels, we certainly appreciate it. Thanks a lot.
Thanks, Roland. Appreciate it.
I'm going to bring my panel right now, get their thoughts on this while we are doing this here. I do want to play the video here of Andrew Womble talking about how this all started as a drug investigation. This is what Womble had to say. Again, it's a 2-minute and 32-second soundbite. So listen to how he detailed what this was all about.
Law enforcement involvement with Mr. Brown began in the weeks prior and put the wheels in motion that eventually led to the attempted service of arrest and search warrants on April 21, 2021. In the early months of this year, Detective Johnson with the Dare County Sheriff's Office received information from a reliable confidential source that Andrew Brown Jr. from Elizabeth City was selling drugs in Dare County. Detective Johnson contacted Pasquotank County and confirmed Mr. Brown's identity and that he is a known drug dealer. Upon learning this information, Detective Johnson, with the aid of the confidential informant, made 2 undercover buys from Brown on March 17, 2021 and March 29, 2021. Those buys were of cocaine and heroin, respectively. A later SBI lab analysis determined that the heroin was laced with fentanyl. Subsequently, arrest warrants were issued for Brown's arrest on April 20th, 2021. Simultaneous with the activity of the Dare County Sheriff's Office, Pasquotank County Sheriff's Office began collecting their own intelligence on the drug activity of Mr. Brown at his residence at 421 Perry Street. Detective Ryan Meads applied for and obtained a search warrant for the residence and vehicles of Mr. Brown. On Tuesday, April 20th, 2021, law enforcement now possessed 2 arrest warrants for the sale of controlled substances in Dare County, as well as a search warrant for the residence and vehicles of Mr. Brown. A joint team of law enforcement from Dare County and Pasquotank was assembled. The Dare County Drug Task Force was to provide surveillance, and the officers present that day were Detective Johnson, Sergeant Ruth, and Detective Langley. The Pasquotank Special Operation and Tactics team would serve the warrants and take Mr. Brown into custody. Their team consisted of Lieutenant Judd, Sergeant Meads, Deputy Morgan, Deputy Llewellyn, Deputy Bishop, Deputy Swindale, and Deputy Lunsford. Deputies Morgan, Llewellyn, Bishop, and Swindale were wearing body cameras. Their original plan was to serve the warrants on the night of April 20, 2021. However, Mr. Brown was not at his residence and could not be located by the surveillance team. At approximately 9 o'clock on April 21, 2021, I received a call from Special Agent in Charge Michelle Rogers with the North Carolina State Bureau of Investigation informing me of the officer-involved shooting. Sheriff Tommy Wooten and I jointly requested the SBI conduct a thorough investigation of the shooting. Shortly after speaking with Special Agent Rogers, I contacted District Attorney Investigator John Young to meet me at our office here in Elizabeth City and to proceed with me to the scene of the incident. We viewed the scene, and later that day I met with Sheriff Wooten, Special Agent Rogers, members of the SBI team that would conduct the investigation. On May 11th, 2021, the SBI lead case agent, Jason Godfrey, began releasing the SBI report gathered to the District Attorney's office. I immediately began review of the written SBI reports and other documents as investigated by the SBI. I reviewed the SBI investigation, which included interviews of the deputies involved with the Pasquotank County Sheriff's Office, interviews of civilian witnesses, interview of Dr. Karen L. Kelly, a forensic pathologist at the Brody School of Medicine at East Carolina University in Greenville, photographs of the scene, ballistics and trajectory report of Cason Reynolds, analysis of weapons and shell casings, the law enforcement personnel records of the deputies involved, video footage of the body cameras at the scene, and the crime scene report. In addition, I have met or had telephone contact with Jason Godfrey practically every day since April 21, 2021. Agent Godfrey and I viewed the trajectory rod analysis performed by Agent Candace Pegram and assisted by Agents Rob Evans and Stephen Stile on April 22nd, 2021. Further, I sought advice and counsel from numerous elected district attorneys around the state who have had recent experience with officer-involved shooting cases. There are 14 houses near 421 Perry Street, and each location was canvassed for evidence and witnesses. 4 civilians provided statements to law enforcement. Ms. Demetria Williams stated she lived in the vicinity of 421 Perry Street and heard gunshot from inside of her residence. She further stated that after hearing the first shot, she exited her home, went down the street, and saw the remainder of the shots being fired. Ms. Williams' home is approximately 100 yards away from 421 Perry Street. The total elapsed time from the first shot to the last is 5 seconds, calling into question Ms. Williams' statements regarding witnessing the shooting. The second civilian to give a statement was Daniel Sturdivant. Mr. Sturdivant stated the incident occurred prior to 8 a.m. He stated he heard officers shouting commands, at which time he walked to his window. Sturdivant stated the officers were firing into the car while they were giving Brown commands to get out. The third civilian to give a statement was Ashley Bechtel. Ms. Bechtel stated she did not see the initial shots fired, but heard them and went to her window. She stated Brown's car was heading over Roanoke Avenue, and the officers were forceful when removing Brown from the vehicle. Bechtel further stated she heard additional shots after Brown's vehicle struck the tree and as officers approached the vehicle. The fourth civilian to give a statement was Amber Santiago. Ms. Santiago stated she was in a relationship with Mr. Brown and stated they had a telephone conversation the night before where Brown stated he believed the police were following him. Ms. Santiago further stated that Mr. Brown said he was going to stay at a hotel rather than staying at his residence at 421 Perry Street. The weapons used by the 3 Pasquotank County deputies who fired were 2 Glock 17 handguns and an AR-15 .223 rifle. These weapons were seized and provided to the SBI. The SBI recovered 14 spent shell casings, 9 from the Glock 17 handguns and 5 from the AR-15 rifle. These 14 spent shell casings were recovered from the cement driveway and in the yard adjacent to 421 Perry Street. These 14 shell casings were consistent with the body cam videos and physical examination of Brown's car as being fired by the deputies.
All right, folks, let's go to our panel. Joining us right now is Killa Bethea, communications strategist. Joining us right now, we also have Benjamin Dixon, of course. Ben is with his own podcast, The Benjamin Dixon Show. And also joining us right now is Makongo Dibinga, professorial lecturer, School of International Service, American University. Ben, I'll start with you. This is frankly no shock. We've seen the actions of this DA from the beginning. We've seen this in so many other cases where the DA acts more like the defense attorney for the officers as opposed to somebody representing the people.
Absolutely. And that's what stood out to me from Attorney Harry Daniels when he said that the district attorney, Andrew Womble, was acting like a defense attorney instead of a prosecuting attorney, a district attorney rather. And so in this case, it really sounds, he gives us the impression in that last 2 minutes that you played, he gave the impression that there was this thorough investigation by the SBI. And he also gave the insinuation, just listening, you would think that the SBI concluded this investigation. But as the attorney Harry Daniels stated, that's not the case. And so we see that he's actively inserting himself into this in a manner that's beneficial to the people that he's charged with investigating. And it just shows you that there's an inherent conflict of interest when a district attorney who is in league with these officers often, at all times, he works with them when he's charged to investigate them. And so this suggests that there should always be a separate prosecution, a separate investigation that is not controlled by the people who are friends with the officers who commit these types of shootings.
Kelly, we've watched this man literally go through this. In today's news conference, he spoke about laying out this, making the decision, how his office arrived at this decision. I want to play this soundbite and then have you respond to it. And so, because obviously he was speaking about the public opinion. The public opinion, how this is being portrayed with the protests and things along those lines. And so let me know when we have that soundbite ready, folks. Again, it's a 1 4-second soundbite.
On April 21, 2021, Mr. Brown's body was transported to the medical examiner's office in Greenville, North Carolina, where an autopsy was performed. The autopsy was conducted by Dr. Karen L. Between police and citizens in which deadly force is used are among the most important cases the district attorney's office will ever handle. My prosecutors and I have a duty to objectively analyze the totality of the evidence and circumstances, and that means we must face difficult issues which have been discussed at length in this report. It is my sincere prayer that no one is ever killed by law enforcement. But I also pray that law enforcement are never placed in the position of having to make the decision to use lethal force to protect themselves or innocent lives around them. I want our community to understand that this office put significant effort into ensuring that this decision was based on the facts, the evidence, and the law, and not on public opinion.
Kelly.
So the thing that I literally just wrote down is how he was saying it's his prayer that essentially police are not ever in a position to do something like that, which is, for me, a dog whistle saying that they were forced to kill somebody unnecessarily so because their lives were in danger, so to speak. But if you look at the very little video that we were able to see as the public, the police put themselves in that situation. They created the chaos. They are the ones who ante upped the response and the exigent circumstances. They created that, and for him to talk about, you know, his office did this and his office did that. There's been no transparency. There's been no collaboration. There's been no cooperation. There's been no working together with the victim in this case. He is acting, I believe Benjamin just said it, as the defense attorney, like we've seen many DAs across the country act like, but he's also acting like judge, jury, and executioner by way of how they've been handling this case. And I wanted to go back to the fact that they are the ones who looked at all of this video, and Andrew Brown's people, his representation, were only able to see less than 20 minutes of it. There's almost 2 hours of video. I believe it's like 5 videos or something like that. They've only, out of 2 hours, they were only able to see less than 20 minutes of it. And it shows me how much of a cover-up this is. It shows me the lengths in which they want to go and are willing to go to evade accountability in this case. And it's not about a few bad apples. It's not about, you know, singular bad cops, because he also wanted to point out that only one person shot, or very few people shot, in the grand scheme of the chaos that was that moment. But the fact that one person shot and the rest of the good apples, quote unquote, did not do anything is showing me that it is a rotten tree. It's not just a few bad apples that are falling from the source of the tree. The entire tree is rotten. And it is unfortunate that justice will not be served in this case, because the people who are supposed to be serving justice are essentially corrupt.
Makongo, all of this to execute a drug warrant?
This is incredibly ridiculous. We just saw in the neighboring state of South Carolina, they reintroduced the firing squad, and now we get to see North Carolina doing it right in front of our very eyes. Again, for a drug warrant. Like you said, you know where the person lives, and you see in the press conference his conversation basically saying, well, this man was involved in drugs. He had a criminal record, as if he was worthy of death. This is a man who was a human being, whose family didn't even get the rights, to the respect to be told that these officers were not going to be prosecuted or indicted in any way, shape, or form, again, over a drug warrant. How many times across the country do we have to see our own people be killed for the most minor of issues? And when I say minor, we know that he was not going to pose a threat to them. He was not armed. We see people shoot up movie theaters and grocery stores who are armed to the teeth and end up surviving. He should have been able to survive this encounter. And as it was just said, these officers put themselves in the line of fire and then say that they are justified in these types of killings. And we see by the video that they made, like you said, Roland, made all of this hoopla about not releasing. But now he's saying, well, there's not going to be a prosecution anyway, so I can do whatever I want with it. Forget the judge. They are working together at the disrespect of this family and to our entire community. And I'm very happy that the federal agencies are going to be looking into this.
Again, folks, the only thing now is what do the feds do? So we'll see exactly what happens there. All right, folks, back to our Roland Martin Unfiltered video in just one moment.
Hello, I'm Nina Turner. My grandmother used to say, all you need in life are 3 bones. The wishbone to keep you dreaming, the jawbone to help you speak truth to power, and the backbone to keep you standing through it all. I'm running for Congress because you deserve a leader who will stand up fearlessly on your behalf. Together, we will deliver Medicare for all. Good jobs that pay a living wage and bold justice reform. I'm Nina Turner, and I approve this message.